what is probate? Probate court in Texas is a court that hears two kinds of hearings. One is for a person who dies, and second is for a person who's sick. So, I die, obviously, I'm not the one going to court. My loved ones are. And they need to go to probate for two reasons. One, I did not leave a will. Two, I left only a will. So, either if you have a will, you will have probate. If you don't have a will, you'll still have probate. One probate is lengthier, longer, more painful, more expensive, and you don't know what the results are going to be. The other probate, if the will is done right, is shorter, easier, but it's still public. It still requires the court to know what you have, and it is published in the county, and it requires an inventory that is filed with the court. The judge decides what's going to happen to your assets and how they're going to be distributed according to your will, and your loved one will have to get that will admitted in court and make sure that it is valid. So when you do have only just a will, you need to make sure that will is valid, and so you want to make sure that you don't just get an online DIY will that you don't know if you have even attested or signed or witnessed properly. You want it done properly through an attorney, even if it is just a will. So that is what probate is, for a will or not a will when a person is not alive. Now, what is probate for when a person is alive? That is the proceedings for guardianship. A guardianship occurs when a person cannot make a decision for themselves because they're incapacitated and they have not planned earlier to give agency to the people they trusted. They have not had a medical power of attorney, they have not given a financial power of attorney, or even if they have done that, at this point they are at a time in their life, in the state of their mind or physically, they are in a situation where they need more than just agency. They actually need somebody to take over everything, their person and their estate, with what is called as guardianship. That requires them to literally have no rights about where they live and what they do with their life. And that is something that the judge takes very seriously. It is something that you want to make sure you nominate, because you do not want somebody that you don't like or a stranger taking over that guardianship. And you want to make sure that the judge does decide based on what your choice is. That is guardianship. Guardianship should never be just put in a will, because a will requires probate. So the guardianship nomination, if it is temporary especially, should be outside the will as well, so that that document can be taken to court separately, which means that you don't have to wait for the lengthy process of probate for somebody to take over guardianship, either of yourself or of your minor children. So that is what probate, while you're living and while you're dead, means. Now let's go on to why you want to avoid probate and how you process that.